Was on bills in the 2024 legislative session in California amending Prop 47. With the continuing rise in property theft and retail crime in the state, we're likely to see quite a number of bills introduced in the 2024 California legislative session that propose to amend Proposition 47, which was actually adopted by the voters in this state in November 2014. Some of those bills will attempt to change several of the provisions of Prop 47 in order to enhance criminal penalties. Now, Prop 47 was titled by the Attorney General as Criminal Sentences Misdemeanor Penalties Initiative Statute. The proponents called the statewide ballot measure the Safe Neighborhoods and Schools Act. Among its provisions was making certain non-violent property crimes when the value of the property does not exceed $900 or $950, into misdemeanor criminal offenses. Prop 47 also changed some simple drug possession offenses into misdemeanors. Among the crimes affected by Prop 47 were shoplifting when the value of property stolen doesn't exceed $950. The same for grand theft, receiving stolen property, forgery, fraud, writing a bad check. Now, if members of the California legislature want to amend Prop 47 to strengthen those laws, take the opposite approach, their bills are likely to contain the following plus section at the end of their bills. This act amends the Safe Neighborhoods and Schools Act, an initiative statute approved by the voters at the November 4th, 2014 statewide general election as Proposition 47, and shall become effective only when submitted to and approved by the voters. The Secretary of State shall submit this act for approval by the voters at a statewide election in accordance with Section 9040 of the Elections Code. Now, why would a bill to amend Prop 47 need to go before the voters? Prop 47 in Section 15 of the ballot measure actually allows the legislature to make two different types of amendments to the measure. Section 15 reads as follows. Section 15, Amendment. This act shall be broadly construed to accomplish its purposes. The provisions of this measure may be amended by a two-thirds vote of the members of each house of the legislature and signed by the governor, so long as the amendments are consistent with and further the intent of this act. The legislature may, by majority vote, amend, add, or repeal provisions to further reduce the penalties for any of the offenses addressed by this act. So as a result of Section 15 of Prop 47, the legislature can amend Prop 47. However, amending Prop 47 to make changes that strengthen criminal penalties or lower the financial threshold below $950 or change certain violations to be felonies rather than misdemeanors do not meet the amendment requirement of being consistent with and further the intent of this act. So as a result, these types of bills will have to go before the voters. California Elections Code Division 9 deals with measures submitted to the voters, and Article 4 of Chapter 1 of Division 9 relates to measures proposed by the legislature. Article 4 was enacted in 1994 by Chapter 920, and specifically Section 9040 specifies that every constitutional amendment, bond measure, or other legislative measure submitted to the people by the legislature shall appear on the ballot of the first statewide election occurring at least 131 days after the adoption of the proposal by the legislature. As a result, bills by the legislature to amend Prop 47 in a manner that is not consistent with or does not further the intent of the ballot measure will have to go before the voters after successful enactment by the legislature and the governor.